Miami-Dade Bar. This is a very new program that we're trying on behalf of the bar. We started a brand new committee called the Foreclosure Committee, headed by our chairman, Bruce Jacobs, and co-chair, Jackie Ledone. They've taken it upon themselves to do this programming, not for attorneys, but for the general public. And the Miami-Dade Bar will be stepping forward to do more to be a public service to Miami.
Looks like we lost Brett for a moment. So while he's working his way back, this is going to be a new series that we're going to be doing hopefully monthly. This is the first one that we're doing. I see that there's, a lot of participants coming on, and that's really exciting for us. And this is being done in conjunction with the Legal Aid Society. They have been helping to push this out and to make sure that everyone, knows that legal aid is here for those of you who need help. And our goal from this seminar is to give people an understanding of what does the lay of the land look like if you are going to be going into this COVID foreclosure crisis that's coming. We've already started to see the new filings starting to spike, and that is usually the beginning of much more filings, and that's how you get into the crisis that we had a decade ago. So before we get started, I just want to take a minute and if you have questions, please put it into the chat, and we will get to your questions throughout. We'll try to answer them as we go. At the end of the presentation, we'll open it up and have people ask. You can ask like live questions, but I just want to take a minute and kind of go through, introduce everyone on the panel, or have them introduce themselves. So Jacqueline is the co-chair of the Foreclosure Committee. She's been with me since the very beginning of this. Jacqueline, you want to introduce yourself? Tell us a little bit about you and how you got here.
Yes, good evening, everybody. My name is Jacqueline Ledone. I have my own firm called Ledone Law, and I started working with Bruce, like he said, when this committee started, it's a recent committee this year. I have been doing foreclosure defense work since the height of the foreclosure crisis back in 2008. That's when I first started doing foreclosure defense work. Have done a lot of appeals in this area, and the case law is a bit tough for borrowers at this stage. And so I like to use different strategies to help keep homeowners in their homes. And we're going to go over a lot of different things, but part of it is going to be loan modifications. And one of the things I'll be covering is bankruptcy options, which I often save as a last resort. If all else fails, then that may be an option for you. And we'll get into that a little bit later, but that's pretty much it for me.
Okay, thank you very much, Jacqueline. So next we have Robert Rodriguez. Robert, you want to introduce yourself?
Sure. My name is Robert Rodriguez. I have my own firm, Robert W. Rodriguez, PA. I too was in the height of the foreclosure crisis. I was with a partner of mine that we handled over roughly about 5,000 clients during that time frame from 2008 to 2013, 14, around there. In terms of what it is that I do, it's basically a consumer protection practice. Focusing now on these foreclosure defenses, and like Jacqueline says, I will echo and harmonize everything that she's saying right now. It's not too good for consumers, but there are some techniques, there are some things that you can do to stay in your home, to protect your home, to get that modification. When you're speaking to these bank representatives, we're going to give you some of that practical information. At least that's going to be part of my segment that I'm going to be introducing. I'm honored to be on this panel with these presenters. They're all aces in this field, and you're going to learn a lot. And like Bruce said, hopefully we're going to be having these presentations more frequently. They're going to be up for you to be able to review and have as a resource moving forward.
Thank you, Robert. And Ricky Corona, the illustrious and immortal Ricky Corona, please introduce yourself, sir.
Thanks, Bruce. Hi, everybody. Good afternoon. As Bruce says, my name is Ricky Corona. I started working in the foreclosure before I became an attorney with my father at the firm of Corona Law Firm, PA. They've been doing foreclosures similar to Robert's old firm, several foreclosure cases and loan modifications, and we also do bankruptcies as well. I look forward to speaking with you all and doing this presentation. There's some things that we're going to talk about, and I echo Robert and Jacqueline's comments with regard to the difficulties we have as attorneys and being able to defend these foreclosure cases with some of the case law that's come out. But we do have some tips that may help you guys be able to save your home, especially with the market that we have today, which is significantly different than the market that we had in the first crash. So I look forward to speaking to you on it, and I look forward to doing this monthly as well with Bruce. And thank you, Bruce, for getting this together, and the Miami-Dade Bar and the Floridians for honest lending as well.
And also the Legal Aid Society. Yeah. So we have, I did want to mention Floridians for Honest Lending. They're a grassroots organization that has really done a lot of good work to try to address some of the injustices that are happening to people. A lot of people, one of the issues they work on a lot are these zombie second mortgages that showed up after a decade, where they're, coming after people for things that have, they thought disappeared 10 years ago. They're back. And they've just been out there for a long time trying to help people, save their homes and deal with housing issues. So Floridians for Honest Lending, please, sign up with them, follow their programming. They're great. So I'm Bruce Jacobs. I'm the chairman of the committee with Jacqueline Ladon, and I am a former Miami prosecutor. I have been I represented banks for years in foreclosures until 2006 when I started my own firm. And then in 2008, the crash, I got into foreclosures. And I've been doing it ever since. To me, this has been one of the most fulfilling areas of law I've ever practiced in. I'm practicing 25 years, but to be able to fight bullies and help people and have wins and deal with losses, it's been quite a journey for quite some time. And I was there along with Jackie and Robert, and I think we were just talking that Ricky kind of got out of law school a little bit after the crash started. But in 2008, I was doing foreclosure defense, and it was a wild ride. It was a wild ride. And the first thing I wanted to talk to everyone about was a little bit about that ride and what that looked like. Because, for those of you who experienced it, what I saw was, the world's economy collapsed. There were all kinds of decent people who suddenly had houses that were worth a lot less than they paid for them. There wasn't a lot of help for the people. Banks were getting bailouts, and those bailouts weren't funneling down to the borrowers. They were just, keeping the banks strong. And a lot of borrowers were left on their own. And part of what I'm hopeful we'll be able to help people with in this presentation is that there were a lot of traps that people ran into. And by the way, guys, you feel free to join in at any point. But what we saw were a lot of foreclosure rescue scams. We saw a lot of foreclosure firms that were, not doing any work. We saw a lot of people that were losing their properties to people who were trying to basically take all the upside and leave them with all the risk. And it was the Wild Wild West. It was a lot of, people getting hurt at that time. And, people that were renting places that all of a sudden found themselves being evicted without any notice because their landlord they'd paid rent to wasn't paying the mortgage. And a lot of stuff like that was going on. And I think that, at least in terms of some of the things that I want to focus on is being very careful who you deal with when you are looking for help. The first thing you should be mindful of, I think, is dealing with non-lawyers. There are tons and tons and tons of companies that set up at the time that were all saying, hey, we'll get you a loan mod, we'll do it cheap, we'll do it fast. They weren't lawyers. And Lincoln Financial was one. I don't know if you guys know have any other war stories, but they were taking people's money every month, and people were just losing their homes, and there was nothing being done. It was just a scam. And they tried to catch some of them, but they didn't catch all of them. And that was happening to a lot of people. It got so bad that the government stepped in and basically shut down the whole foreclosure rescue program, you couldn't charge upfront fees, which are still laws today. You're not, if someone comes to you and says, give me X dollars and I'll get you a loan mod, and they're not a lawyer, they're breaking the law, which is something that you should be thinking about when you're deciding how am I going to get help. I think that people sometimes lose sight of the fact that, this is the most expensive asset most people have, their home. And if you handle it wrong, it's going to cost you time and money and stress and aggravation that, is worth a lot more than the money you're going to save. When you actually lose your house and have to go pay rent somewhere else, that's a reality check that you're going to, realize you're going to spend a lot less on that, but a lot more at that time than you might have spent on a good lawyer. One of the things I want to talk about is just to get a sense of how what kind of fee structures people were using, back in the day and still today, in order to kind of, figure out, like what these people should be expecting. So does anyone want to share, what their fee structures look like back in the day?
And we can start with Jackie. She had the best one.
So I was working at Legal Services of Greater Miami for from 08 to about 2018, 2019. And that is for those who qualify. It's based on income and also on your age. If you're elderly and meet certain requirements, you may also qualify. And there's no charge. Legal Services is a pro bono organization. So if you qualify, meaning you're low income, or perhaps if there are certain grants that may still be there if you're over 62, I believe. And there's no charge at Legal Services. So
Awesome. If you can get to Legal Services, I will say, they carry a lot of the load for, this journey. They've done a lot of great work, and they are certainly worthy of, of consideration. They have the resources to work with. They have, lawyers that they work with that all, are working together to kind of help with these cases. And, if you're able to qualify, that's certainly a good option, better option than going with someone who's not a lawyer 1,000 times over. What about you, Robert or Ricky? You guys want to talk about your fee structures?
Sure. I'll let you know. Initially, when I first started this in 2008, like you indicated, it was the wild, wild west. Everybody was kind of like trying to figure out how to do the representation models. They kind of had to be created on the fly. Initially, the way it was being charged back in 2008, and I'll tell you how I'm doing it now. In 2008, I would go ahead and charge an initial retainer fee of probably $500 or $1,000, depending on the complexity of the case, whenever I would see the foreclosure complaint come in. And then at some point, we'd start charging on a monthly fee. And then soon we realized that wasn't something to be doing. We just went ahead and said, okay, this is going to be the total fee that we're going to charge in a foreclosure defense, whether it was $2,000 or $3,000, and then the client would pay anywhere between $400 to $500 a month until they got to that number. They could also pay it up completely upfront, but we would discourage that. I discourage that now in my practice because sometimes I can resolve a case in a month. I can resolve it in 2 months, depending on the willingness of the lenders to go ahead and participate in modification processes, and depending on the strength of the income of the client that's coming in. As you know, Bruce, what we're seeing right now, I think the other panelists also, we're starting to see these forbearances they're coming out of forbearance, and now the lenders are not helping them come back in to restarting a monthly payment. Usually when I mount a defense on a foreclosure with something like that, when the bank sees that there is a defense and that there is somebody representing the consumer or the homeowner, at that point, they will go ahead and start engaging in negotiations. At least that's been my experience up to now. I don't know how it's going to be now with the onslaught that I see coming with respect to the foreclosures down the pike, but that's pretty much the fee structure that I have currently right now. I will quote a certain fee, and then the person can go ahead and pay on a monthly basis until they reach that number. I try to make it as accommodating as possible for them.
What about you, Ricky? How is your world?
We've changed and we've adapted, and initially we had a flat fee, and it was a little difficult when there was a ton of foreclosures to be able to continue off that fee. So we had to adapt and change. And, you know, we try cases, we go to trial, we try. We go to every case planning on trying the case and preparing the case for trial, like everyone on this panel does. So, you know, we litigate the cases, and, you know, it all depends on the facts, where in the process they are. If it's a case that's already set for trial, it may change. So our fee structure depends on, you know, different things, but we try to make the payments affordable and work with the clients. One more thing about the legal aid that was discussed: legal aid, if you can't qualify, reverse mortgages. Jackie, the work that Jackie did over there, and the team, and not only the people in legal aid, they also have attorneys, and we've worked with legal aid on some cases, and we've been, you know, on some cases that we work with them. Jackie's work that she did there was beyond excellent. The work that she did for elderly borrowers, reverse mortgages, where we saw that, like, the worst abuse that you would see, and we still continue to see those cases. It's very sad with people when they're in their late years of their life and have to deal with a foreclosure, some alleging that they don't live in the property when they actually are being served a foreclosure at that same property. And you know, so going back to the fees, I guess we'll talk about some of the other stuff with foreclosures, but the fees, it depends on the case, depends on, you know, it's different circumstances, but we try to keep our fees affordable for everybody.
And just, you know, I'll throw in my 2 cents. So, you know, I saw back in the day, you know, it was pretty standard that people would charge something like, you know, $1,000 or $1,500 down, and then $300, $400, $500, $600, $700 a month. And, you know, that was kind of market rate. And you would get that for a lawyer who would fight your case like Ricky or I or Robert would do, like all the way, or Jackie would go all the way to whatever it is we had to do, to the death, you know, or to the settlement, or to the, you know, whatever it turned out to be. Or you'd get someone who would take that money, and then when they're, you know, when the case got called up for trial, would tell you, hey, you got to take a consent judgment because you have no defenses to foreclosure, and they were never planning on trying your case to begin with. Over time, my fee structure worked out because my practice is very, I never really liked the modification model. I always thought it was that I was going to just litigate the cases. Most of the clients that came to me didn't really want to take the deals that were getting offered, and they would find, you know, they would come. I get, you know, people coming to me saying, I was here and then like with the results they were getting me, so I want to fight, and that was what I would do. I did a 3-part fee structure, which is usually an initial payment, a monthly payment, and then a success fee if I was able to get you success from the, you know, from the case. If I was able to get them to pay you money, or if I could get them to knock off the debt, or if I, you know, I'm proud to say in my 14 years of doing this work now, I have successfully gotten 2 people a free home, which is unheard of in Florida. All you people who think, hey, I'm going to hire a lawyer and he's going to get me a free house because, you know, we're going to, you know, that should be pretty easy, should recognize that that is definitely not easy to do. And it happens in very, very rare circumstances. You know, but there are, you know, good stories and bad stories. My recommendation is if you could relive what we saw back in the day, you know, my recommendation to most people would have been to be, you know, trust but verify. You know, if you know, a lawyer should try to work a case out, but should be ready to fight if they don't. And that is something that if you don't see your lawyer litigating the case, and you can nowadays, everything's filed electronically. So, you know, our practice is to send copies of everything that comes in around on a case to the client that, you know, within short order. So if you don't see things getting filed in the court, then you should be concerned that your lawyer may not be doing what he can to protect you. If, you know, if you're calling, months and months are going by and nothing's happening with your modification, you know, it may be that they're not, you know, it may be the bank's fault, but it also may be that the people you're working with aren't, you know, following through the way they need to. You know, sometimes they take on a lot of cases and don't, you know, have the staff to do the work on those cases. So mean, is there anything that you guys want to share about your experiences from the first foreclosure crisis that, you know, you give words of warning to, you know, all of the people who are watching this, things to watch out for that might be something to be concerned about?
I'd like to go ahead and comment real quick, and I know that this process is a very it's a fearful process. It's a very apprehensive process, especially for the homeowner. One of the things that I kind of like pride myself on, and I think that we all do on this panel, is communication. Bruce, you said it. You send all the pleadings over, like to your clients, you know, by email, by courier pigeon, by snail mail, whatever it could be, but to let them know that stuff is going on in their case. I think that's what anybody who's watching this particular webinar, you got to ask how the communications are in the office, because, you know, sometimes you may not see activity occurring for, you know, a couple of weeks, and you start saying, wait a minute, I haven't heard anything, I haven't seen anything, whatever. There has to be an open line of communication between yourself as the homeowner and the attorney's office, with the paralegal, directly with the attorney. Myself, I always give out my cell number. I think in today's day and age of practice of law, it's all about communication and just kind of like shepherding through the homeowner through this very, I guess, turbulent process and inexplicable process, because sometimes we have the same bank, we have the same homeowner with the same set of circumstances, and they approve one for a modification, they don't approve one for the other, for a modification, even though they're the same. I think communication is the key. At least that's what I learned from the 2008 experience. And moving forward, as soon as I went ahead and just disseminated all the information and made myself available for these clients and just explained to them, it usually takes a 2 or 3 minute conversation. Everything's okay, don't worry about it, we're moving forward, we're doing this. It keeps clients knowing that the attorney has the finger in the mix.
Jackie, Ricky, anything you guys want to share?
This is less applicable if you're working with an attorney, because I don't think it's going to come up as much. But one of the largest issues that we tackled at Legal Services was the foreclosure rescue scams that you mentioned. And so I think a huge red flag that homeowners should be aware of is if they're working with a non-lawyer or any other organization, or even honestly family or friends, and somebody's asking you to transfer title, that is a big red flag. There are a lot. I spent a lot of time trying to get people back their homes and undoing these deeds where they didn't understand what they were doing. In today's market, that may even be a bigger concern because there's more equity in the properties. When we did this and started back in 2008, most things were upside down. And we're not seeing that today. I think properties have retained and probably gained a lot of equity in the current market. And so this might be something you come across. And it's a type of thing that once you turn over title, you know, you're giving up your rights to your home, whether it's partial or fully. And if there may be lots of different options, which we're going to go over. And especially given the fact that there is more equity and rates are lower than they have been in the past, you know, a simple refinance might be an option. And I guess my concern is, because if you're behind on your mortgage and you may not have the greatest credit rating, it may be tempting to turn to a family member or friend and say, well, you know, co-sign for me and I'll add you to title. And then, but it leads to a lot of problems. So I would caution anything that requires you to transfer title as not a good response.
That is one of the most sought after scams that they try, is to get you to give them title to the property, tell you that they're going to take care of everything, don't worry about it, they'll make it all go away. And then they rent your house out, collect all the money while you're living somewhere else. And eventually you get foreclosed on, and it's your credit that goes into the tank. And those people were not able to save lots of those people. And it's the sales pitch guys you got to watch out for, the ones who were talking about the Obama rescue plans and how they can do it because they know how to get these banks to do, like, work with a lawyer is my recommendation. If you can't afford a lawyer, go to legal aid. But if you start getting into situations where you're giving away your title, you're going to be giving someone else a chance to make all the money they can off of your property, while you're the one who deals with all the negative effects of them playing the games. When they finally foreclose, if there's not enough equity in the house to pay off the debt, they're going to come after you for the amount that. So not to the people that took your house. Ricky, you want to share anything?
No, just I think the biggest difference between now and 2008 up until I think even like 2016 was the ability of the courts now to handle a new foreclosure wave and the timeline of that foreclosure process. Before those foreclosures, dragged on for years, where we're not having that anymore. The Supreme Courts have issued orders on all cases, on all civil cases. But I think that the courts have also were able to adapt to handle foreclosures and to not have the backlog of foreclosures if there is a new wave. So I think that it's that, and like Jackie says, that you have equity. A lot of these properties, for the most part, almost every property has equity right now. Almost every loan out there, especially in Miami and Broward in South Florida, the majority of these loans have equity. So there are going to be people out there trying to offer you maybe nominal amounts of money for your title, and they'll take over the loan or anything like that. You shouldn't. I mean, if you could save your house, with what the price of rents are right now in South Florida, with an increase of rents yearly, if you could save your house, do everything you can, and definitely you should hire an attorney. Don't hire anybody that's not an attorney. You could get you get significantly better representation by an attorney, and maybe for the same price or even better than whoever is the non-attorney out there. So that's what.
And one other thing I want to talk about are these mortgage forensic auditor people out there. I'll say this: in my years of going to trial, I've seen lots and lots of clients come in with these audits, and they're long, and they have all these statutes that they cite, and there's all this stuff that, like, you're supposed to be able to get the banks to go, oh, wait a second. Most of it was a waste of money. The people weren't qualified to testify in court. The judges didn't accept them as experts, and it gives a lot of people, I think, false hope. It gives them, an idea that, like, oh, if I spend this extra 500, 1,000, 10,000, whatever the number is, they can get out of you. These guys are not lawyers. They are, I think, essentially practicing law without a license. And, look, this is the largest asset most people have in their lives. And if you're going to lose it, you should be talking to lawyers and getting the best advice you can, experienced lawyers, as opposed to talking to, anyone that comes in off the street. That's not a very good situation. So what I wanted to segue into now is, we were just talking about how important it is to save your house. And for those of you who don't, I have my own views on why the affordable housing crisis is escalating at a faster and faster pace. And part of it is that Wall Street banks have invested hundreds of billions of dollars in recent years to buy single family homes in areas that we all want to live. And they're not buying them to flip them. They're taking all the properties that are coming off the auctions from the foreclosure. And now they're out in the street. When a realtor puts up a house for sale, they can get multiple offers, cash, ready to go. And it's hedge funds with unlimited resources that are trying to buy as much property as they can. They put the properties into a corporation that's going to basically be the slumlord, the landlord. And what you're seeing is they're increasing the rents, they're securitizing the rents, they are looking for any way to nickel and dime and increase their profit margins, because that's how they get richer. And, I always say Thomas Jefferson once said that banks and the corporations that rise up with them will one day leave our children homeless and penniless in the nations our fathers founded. And this is what they're talking about. Exactly this. Teddy Roosevelt fought JP Morgan 100 years ago to fight monopolies, because monopolies that are more powerful than the government lead to this kind of scenario where people can't afford to find a house and to have a life and to do the things that need to be done. And if you're in a house now and you lose your house, you're going to be falling into that, wave of people who are going to have to spend more and more of their income on rent. And that is a very, difficult and scary situation for a lot of people that, I don't necessarily know how we're going to fix all this right now, but that's why I and all these guys do the work that we do, is to, I look at it like it's a class war, and we represent the middle class and everyone, below. And, the 1% are doing what they can to enrich themselves. So the idea for me that I wanted to go into now is like, so how do you save your house? What happens when, now you're in this situation where your forbearance is over and you're supposed to make payments, but it was COVID, or it was, an illness, or it was a job loss, or whatever it was. And now you're needing to find, an answer. So one of the first things that we are going to talk about is loan modifications. All right. And loan modifications means that they're going to take your loan and they're going to modify it. And they're going to, if they're willing to do this, they're going to give you a new loan term. And if you make the payments, you'll stay out of foreclosure. So this wave, I think, is a little different. Has anyone been doing and been seeing the loan mods that have been coming out recently, especially for people like post-COVID that are dealing with that?
I did one. I did one a couple of months ago. Came out of a forbearance, and this particular client, it was a realtor, and they were offering her a steady modification immediately coming out, but she wanted to go ahead and pay the arrearages 6 or 7 months down the line. This particular, it was a servicing agent, and they were a little bit more amenable to helping her out, but she had to do certain things in order to go ahead and get to that point. And that was one of the points I'll talk about later in terms of what people can do when they are talking to that bank representative in order to go ahead and pin them down into a certain modification. But I have had already one experience after COVID with a forbearance, and it was successful. And I had another one that was not successful. They wanted all the money up front, and the client just simply doesn't have it. So we're kind of like waiting and seeing at this point, and it's probably going to go into a foreclosure, a litigation standpoint. And then at that point, we're going to have to go ahead and present our defense. Luckily, this particular client created the evidence that again, like I'm going to talk about later, but they created the evidence chain necessary in order to defend the case. And I think it'll be successful, pushing them into a modification eventually.
Okay. And Ricky or Jackie, you guys want to share anything about any recent experiences with modification?
I mean, we've seen cases where people have gotten approved for the modifications, and we've seen cases where people have not gotten approved for the modifications. With regard to the forbearances, a lot of forbearances had different language, and that's why it's very important. And we talked about, we told all our clients when they were considering those forbearances to make sure you read the language in the forbearance as to what is required at the end of the forbearance. Some of those forbearances have options for the banks to choose from, including requiring all the payment at once as soon as the forbearance expired, or other options. But for the most part, the banks, with those options that they're given, they will take the option of requiring all the payments at once. So we've litigated cases even when Irma came with forbearances where that language was included in there, and that's a contract that people agree to. So definitely start sooner than later on trying to save the house and trying to start that modification and following the steps that Robert has talked about and we'll talk more about today to make sure that you keep that paper trail of what you've done.
Jackie, anything you want to add?
Not specifically on the loan modifications, but I did want to go back real quick because there was a question in the chat and something Ricky said reminded me. And the first thing is read what you're signing. So one of the questions in the chat was, how would a homeowner be able to detect a potential foreclosure scam? How do you know how do you identify somebody's trying to take your title? And so the most important thing is to read everything before you sign. Florida law treats it as if you signed it, it assumes that you read it. Make sure you understand it. A lot of these court documents and loan documents, they're not easy to understand, and probably purposely so. And so finding a good attorney who can help you make sure you understand the terms of what you're agreeing to, I think is critical. A couple other outside factors that might help you, kind of be aware if somebody's trying to take your title is, are there witnesses present? If you're signing a simple like, hey, I'm retaining your services either as an attorney or one of these, a loan mod company or something else, you don't need witnesses. But if you're transferring title, you do. So if there are witnesses in the room, that would be something I'd be wary about. A lot of what I used to see is put a stack of papers on in front of you and they just lift the corner. So you can just sign that little corner, but you can't see everything that you've gotten or everything that you're signing. So if that's happening, I think that's another red flag. If you're not getting a complete copy of everything you're signing, that's another red flag. The whole, I'll email it to you, or I'll send it to you later. That would be concerning for me. I wouldn't sign anything if I can't get a copy right then and there. And finally, one of the other things that might give you a clue as to, hey, this person, is not legit, they are trying to take title. The property appraiser will send you a notice when there's a transfer in title saying, hey, this new deed has been recorded, just here's a heads up. If you're still living in the property, you'll get it. If you have a mailing address, you should get it. But if you've left the property and you've got your mailing address with the property appraiser to the home, then that might be more difficult. But that would be the last thing I'd say in terms of tips on how to beware of somebody who's trying to take your title. But yeah.
Thank you, Jackie. So what I want to talk about for the loan mods, what I think we're going to see now, look, at the end of the day, the law has come down pretty aggressively in favor of banks. So there are not nearly as many defenses as there were when we all started this work, a decade ago. A lot of the law has been determined and the banks have conformed their business practices to the law as they see fit. And there are things that we fight about. I still have cases that, I still have open cases from 2008. That is, a reality that some of these cases can last that long. And I have a client that I got involved in her case in December and they sold her house by April. So, there's no, there's no magic to it. There's, I believe that, some of this is just in God's hands and, some people will have longer time, some people won't. But I will say that in my experience, what everyone in the system wants you to do is to try to get a loan mod before you fight, before you file bankruptcy, before you do anything. And the system is designed to get that in place because, the banks have, programs laid out. Just so you know, there's servicers that are managing all of these files. And those guys are the ones who have the obligation. They have on their website, here's the modification paperwork, fill it out. You have to fill it out completely. If you fill it out halfway, they're going to tell you what you didn't do, and you'll spend time going back and forth about that. But there is a procedure in place that is governed by federal regulation that when you have a completed package, a loan modification package, and you give it to the bank, they have 5 days to acknowledge that they've received your package. If they don't acknowledge that they've received your package within 5 days, they're violating the regulations. They have 30 days to give you an answer, to tell you if you need anything else. If they don't give you an answer within 30 days of a completed package, then they're violating the regulations. If they don't process your modification correctly, they're not following the regulations. And all of this, there's some lawyers that will actually take on these federal lawsuits about these federal regulations. And it's granular. It's a very, complicated system. I don't recommend that you try to do it yourself unless you've really spent some time learning these practices, because, everything is about giving the bank notice, and giving them notices of error and telling them, hey, we want documentation and more notices of error about those. And that's how you can create an actual federal lawsuit. But even that federal lawsuit doesn't give you, a defense to foreclosure. It gives you damages for violating the process. But the more, I believe that there are, opportunities to resolve the case if you're doing it correctly. And one of the things that I know is an issue is these lenders make money by servicing loans in default. They make more money than they would if the loan was performing. That is a fact. That is why they foreclosed, I believe, on millions of homeowners around the country, is because they made more money by foreclosure. At the end, when the house got sold, they got a check for all their expenses, all the costs that they put out, everything that they did. And when the mortgage modified, they had to be given incentives in order to do the modifications, because those incentives turned out to be a little bit less than what they would have gotten had they just foreclosed on you. And, you know, when you're talking to these people, especially if you're talking to them yourself, like, understand their goal is not to get you into a modification which gives you the best result, where you get the biggest reductions in your principal balance or the best terms. Their goal is to get you to do a forbearance agreement that basically just keeps turning their money for them while you're still in the same harm's way that you're in. Why? Because they make more money that way. And, you know, a lot of times when it's what you say to them as you're having these communications, and, you know, they are documenting everything you say. They record the conversations, they take notes about the conversations. And if they're able to give you a, you know, a forbearance agreement instead of a modification that would have done more for you and your family, they'll do that all day long and twice on Sunday. So, you know, one of the things I know Robert, you know, has some good information about, I want to give him a few minutes to talk about this, is, you know, so when you're ready to sit down and do a modification, like, what do you do to document and protect yourself during this process? Because I will say that I've had clients who told me, you know, they were getting the robocalls every day, and they'd sit on the phone for an hour and a half crying, telling their life story about how they're in so much trouble. And you know, they would do whatever they could to try to, you know, do the modification process, and they just didn't really know what they were doing, and they never got a modification. And, you know, some of my clients that I'm still litigating for went through that journey. And, you know, Robert, what advice would you give people about, you know, if you're going to do a modification, what's the best way to protect yourself through that process?
And it's a great question. And before I get into the weeds on that a little bit, I would want to ask you, Bruce, is a bank obligated, so that everybody can listen, everybody can hear, is a bank obligated to give you a modification? That is, do they need to negotiate with you obligatorily or no?
So there was a time during HAMP where the banks were supposed to do a certain waterfall analysis, and it was about your income and about your property value and whatever it was. And if you qualified, you were supposed to get a modification. If you didn't, you can appeal it. If you proved that they, you know, if you did everything under Reg X and Reg Z, which are these, you know, federal regulations that put them on notice, you can go in and sue. And if they're foreclosing on you while they're considering your application, these are all things that you could go into court and try to sue on. But federal court's a tough place to litigate. And, you know, it used to be that, yeah, you should have gotten your modification, you could get it. Now I think that there's certain, you know, programs Fannie and Freddie have that will be, I think, a lot easier to get it when you deserve it. But private lenders can do it. There's no obligation under law for you to walk into court and tell your lender, especially if they're not a government lender, if it's just a private company like a securitized trust or whatever, hey, you have to give me a modification. No, they don't. They don't have to give you anything. They could foreclose on you and come after you for a judgment and, you know, bury you as deep as they want to. But, you know, that's why, you know, if that, you know, sometimes that's why we litigate.
And dovetailing now into this, this is the advice that I usually give clients initially, because they haven't gotten into foreclosure, nothing's happening or whatever, but they're supposedly, quote unquote, talking with the bank. What I try to tell my clients is you need to create documentary evidence. You need to create some sort of evidence to memorialize the conversations that you've been having with these representatives on the phone. I usually hear from my clients, but wait a second, but the representative, I hear them typing, they're putting all the information down in the computer. Well, that's going to probably be protected or privileged material that we may not have access to as attorneys. So what do we need to do to create this kind of evidentiary chain based on the promises that these representatives are giving you when they're talking to you on the phone? And I would tell you, the first thing you need to do before you call the bank, you sit down, you take out a piece of paper, you take out a pen, or you have your laptop or whatever, and then you go ahead and you call that bank. You speak with that representative, and the first words out of your mouth have to be, what is your name? What is your email address? what is your fax number? They might be hesitant in terms of giving you an email address, okay, that they just within the organization because people are coming and going or whatever. But they'll tell you, okay, look, this is our fax number. If they ask you what's the purpose of the fax number or the email, say, no, just in case I need to get in contact with you. And they're usually going to be receptive to giving you, at a minimum, a fax number. And the reason that you're getting this information and you're getting the name of that representative is because now you're going to have a conversation with that person. You're going to say, listen, what do I need to do? Or I submitted my application. What is it that you're missing? Whatever the conversation is going to entail when you're making contact with that bank. And they're going to go ahead and start rattling off certain things to you. I've had clients that have told me, well, they told me that I was already approved or that I just needed these 2 documents and that I would be approved. All that information you're going to be jotting down, scribbling it down on a piece of paper, because when you hang up with that representative, you're going to go ahead and confirm your conversation in writing. You're not going to ask them to generate a document for you saying, hey, can you send me an email or can you send me a fax stating that everything that we talked about? And they'll tell you, yeah, sure, no problem, whatever. They're never going to send it to you. It's just not going to happen. So now you have their email. If you were lucky enough to get the email, at a minimum, you're going to get the fax number. And you're going to go ahead and send them a quick note, basically with your loan number on top. And you're going to go ahead and put dear so-and-so or Mr. So-and-so, and you're just going to rattle off the things that were discussed. And it's something as simple as putting, this will confirm our conversation that we had, for instance, today on April 7th, where you stated or where we discussed, and you're just going to put 1, 2, 3, 4, whatever those points are that you discussed. You told me that I just needed these 2 documents and that I would be approved, or you're already approved. You should be receiving your modification package within a week. Whatever the case may be, whatever it is that you discuss with them. And sometimes it might be in the interim of getting in this modification process where you have to call them 3 or 4 times in order to go over things. Every single time that you're calling them, you're doing the same process, taking out a piece of paper or your laptop, getting their name, getting their email, getting their fax number, and then always confirming the conversation afterwards. As soon as you hang up, don't leave it for tomorrow, don't leave it for the next day, do it immediately, where it just basically says, this will confirm our conversation where we discussed, boom, 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 boom. And you always finish it up with the last paragraph that says, if this was not our conversation, please respond within 24, 48 hours, whatever time frame you want to give them. And that creates evidence. That creates evidence for us, because what happens a lot of times is that these representatives are lying to you. Oh my God, they're lying to me. Yes, they're lying to you. It's not that they're doing it on purpose, but they get these edicts from their supervisors, from whoever it might be, saying no, but they had to have this other document or that document. But now you have a confirmation, because they're not going to respond to you within those 24 or 48 hours. Now you have a confirmation of your email or your fax number or the fax that you sent over, indicating what is it they discussed with you. And in law, these things are called novations. They might have modified the mortgage without them even knowing it. And now you have a feather in your cap that when you give all the information to your lawyer, if they do a foreclosure on you, now the lawyer can use that as an affirmative defense, even possibly countersue the bank in order to go ahead and get fees from them. The idea is to create the evidence necessary, to create the pressure necessary in a litigation to force them to modify. Like Bruce said, the end game here is on your side is to go ahead and try to modify this particular mortgage if you're having trouble. But you need certain elements, you need certain pressure tactics. And by creating this documentary evidence for yourself, for your own case, it's a simple process. It's not that hard. It's not rocket science. It's very simple. And listen, I'm going to say the procedure again. You sit down with a piece of paper or a pen or with your laptop, and you're talking to this representative. You get their name. If you can get their email address, you get their fax number. Then you just put on a sheet or on the email the loan number that you're communicating on. This will confirm the conversation that we had on April 7th, where we discussed, and you just rattle off everything it is that you discussed. When you take that to your attorney, if you fall in the unfortunate circumstance of getting into a foreclosure, the attorney will know what to do with that. Now we have defenses that we could use, possibly counterclaims against the bank, and that is going to force an atmosphere of pressure for that bank, for the attorney who's representing the bank, turning to his representative and saying, hey, listen, we got a problem. We got a problem here because your representative confirmed this or whatever. They even put a paragraph at the end saying if this was not what was discussed, they even gave you time to try to resolve this or to say no, it wasn't, and you did. By the same token, I'll tell you, don't go rattling off things that were not discussed, because that will be fraud. So don't get into that also. Don't put on there, oh, you told me I was going to get a modification. I'm telling you this also so you don't step into that trap. Just go ahead and document everything it is that you've been discussing. And that'll be sufficient enough for your attorney to go ahead and defend you and possibly create the atmosphere necessary to get you that modification.
Thank you, Robert. That's excellent advice. There's something called the present recollection recorded is what I think is the legal term for what he's describing. And it's true. If you write notes as you have them, they can admit them into evidence. This is what happened. That's how they get their records in. If you come back weeks later and try to write down what you did, it doesn't work. It's got to be writings that you made at the time, sitting down and recording what you did. So that's excellent advice. And that does apply whether you have a Fannie Mae loan, a Freddie Mac loan, a Bank of New York Mellon loan, a US Bank loan, one of these, debt buyers that bought loans, like whatever it is, whoever you're talking to, document it. That's a very, very, very important thing to do. So I think that it's important to recognize, as far as loan mod goes, I have seen very, very few instances in my life where you get a modification agreement that offers you something and they let you negotiate those terms. It's usually a, take it or leave it situation. Now, that's not always, I'm not saying that that's always the case, but I think that that's something you should be careful about and considering, because I know there are a lot of people who were like, no, I'm not going to do it unless they fix my credit or unless they change the interest rate or whatever it was. And they walk themselves out of a chance to save their homes. So it's something to really be careful about. If you do get a modification, if you follow the terms of their agreement, then it's an enforceable agreement. If you don't follow the terms of the agreement because you don't think that they're going to do it or whatever else it is, whatever your reasons are, then you are making sure that you do not have an enforceable agreement. And that is, a problem that, I want to make sure that, people understand. These banks are rolling through. If they do give you a modification and you take it, it should be enforced. You can go into court and say, hey, we have a deal. And I honored my end of the bargain. And if you, it's like not paying your rent because you want the landlord to fix the AC. Landlord can go into court and get your, get you evicted a lot faster than you can get him to be forced to pay the AC. And you can't, unless you do things, in a very, very correct way under Florida law, you usually aren't going to win when you say, hey, I had to pay I was living without AC. That was, that's why I stopped paying rent. Most judges are going to throw you out of the house on that kind of thing. So, I think that, what you're going to see is, first plan of attack should be try to modify, look for whatever help you're going to get, and recognize that when that, help comes, you either take it or then you fall into the next wave of this, which is foreclosure. So, what happens is that, there comes a point, usually 90 days of default, where they will issue, or 60 days, they'll say, all right, you're now officially in default. And they are going to send a letter out as required by the mortgage that says you are hereby in default. And if you don't pay the balance that you owe, which is X dollars, which is, all the arrearages, then we're going to accelerate your loan. We're going to start foreclosure. So when that happens, they're going to go to court and they're going to file a lawsuit and they're going to send out a process server. And that process server is going to show up at your door. And it could be in the morning, it could be at the night, it could be whatever time they want. And they're going to knock on the door. And if you or anyone over 15 that lives with you opens the door, they're going to hand that document to you or whoever that is, and you're going to be served. Now, service of process is something that we have fought about successfully in a lot of cases because they don't always do it right. A lot of times they'll, serve someone who doesn't live in the house, or they will serve someone who's 12 or they won't even serve it at all. They call it gutter service. They just left it in the garbage, and those are realities that you can litigate about. Some people win them, some people don't. But even if you don't get served, what usually happens is that your mailbox will fill up with solicitations from lawyers that are going to tell you you've been sued. So you have an obligation or a decision to make at that point. In Florida, even if they don't personally serve you, because it's a foreclosure, they can, show the court, hey, we looked for the guy, we couldn't find him, and publish an ad in the paper. And next thing you know, you get serviced by publication and they move forward without you. So, my recommendation to a lot of my clients has been, service isn't a great thing to fight about, unless you're, in a place where they already got you and you can show that service was an issue. But I don't like to play the service game. I'd rather just get into the fight. And what happens when you have a foreclosure lawsuit that's starting, especially, this wave that's going to come, is, there's two different paths that I see foreclosures taking. One is this expedited order to show cause proceeding, and the other is a regular foreclosure. And the difference between them is there was a statute that was created during the crisis that said, if you file this thing called an order to show cause, and the judge, you put in all your paperwork, the judge will set it up for a hearing, and if nobody shows up, they get a judgment right there. And that's how they took a lot of people's homes, because it was designed for people who didn't stand up for themselves, or were the properties were vacant and they left them, or whatever it was back in the day. But usually you're able to defend the cases. What I would, I very rarely have had a case go on an order to show cause once I get involved and start raising defenses, because you're raising defenses. But having a response to a foreclosure, one of the biggest things that I find to be just so frustrating from a class warfare standpoint is it's like 90% of people who get sued on credit card debt that just don't show up to court. And, the numbers were around that height for foreclosures. And if you don't show up to court, then you waive all your defenses and they get a judgment, and they're not going to work with you. I mean, some of them will anyway. Like I had a client, we fought them for years. We lost the case, they got a judgment, and then we got a loan mod. So there's never, there's always a path, in my opinion, but it's something to be careful about. When the lawsuit starts, get a lawyer, go see legal aid, go talk to a few lawyers. Don't just take the guy you hear on the radio. Some people had a business model of, we're going to invest $10,000 a month in the radio, and everyone's going to call us, but we don't know what we're going to do. And we don't really have a plan. We're just going to take the money and run. And, they sounded good on the radio. There are lawyers who've been doing this work for a long time. Find them and work with them, because you have a better chance of saving your house if you have a lawyer who can help you. But, a lot of times, like, I'm kind of interested to hear from you guys, like, what kind of messes did you see people getting into when they were getting sued for foreclosure? And, like what mistakes were you seeing people making that you had to clean up when they finally came to you?
Bruce, before that, going into what people can do or what are requirements for the loan modifications. If you have an FHA mortgage, there are actual requirements that need to be met prior to a foreclosure being filed, and they have to do counseling and things that are required under the HUD regulations. So there are, there are regulations for certain lenders. So while you can't force a bank to provide you a modification, there are regulations that do support the borrowers, and the HUD regulations are a defense to foreclosure because it's a condition precedent to foreclosure if the banks don't comply with them. There was another question, I think, on the chat there with regard to successors in reverse mortgages. There are options, not necessarily to satisfy the loan, sorry, you could pay off with 95% of the value. And Jackie worked a lot on these reverse mortgages. Again, Jackie, well, the work she did with Legal Aid was excellent. And a lot of the cases that we had that we're able to use were some of Jackie's cases, even to the Florida Supreme Court, which recently. But the successors do have some rights, but unfortunately they're not actually borrowers or they don't have the rights to modify those loans. But you do have the right to refinance that loan because you're technically the person that now owns the property. So you can try to refinance it, and a lot of those loans have equity. We do see a lot of times that the banks charge a lot of fees that they were not allowed to charge, and they put them on the successors to the people that took over the reverse mortgage, all that interest that the banks were accruing, but in addition, those servicer fees that Bruce was talking about too. So I just want to touch on that, Bruce, before we went into the actual foreclosure process, that there are defenses that can be made because of the failure of the banks to comply with the conditions preceding of following the regulations with counseling borrowers and face-to-face interviews.
Okay. So anyone else want to share any other thoughts about like when the foreclosure hits, what things what mistakes do you see people making back in the day that you're hoping they're not going to do again?
I think you hit the nail on the head. I think it's, people get scared about this process. They get sued for the foreclosure, and then they don't do anything about it. It's surprising to me sometimes when people come to see me, and there's already a summary judgment entered. They never answered the complaint. All the affidavits were filed accordingly. I anticipate that we're going to see tougher rulings against consumers with the new motion for summary judgment procedural statute, with the statute that came out now, with judges making these decisions without even giving an audience to us. But I would say, I would echo what you said, Bruce. You got to face it. And information is the enemy of fear and fraud. A program like this, a webinar like this, is giving you information so you realize, like Ricky just said, there are defenses to these cases. These banks, they do not get it right the majority of the times. If you have an attorney who's been dealing with this kind of procedure before, who's dealt with this process before, and these panelists are more than well equipped, that's where you go. That's where you get the defenses. That's where you get your chance to get your modification and kick the case out of court.
I mean, I think that when foreclosures start, you kind of got to make a decision early on, in my opinion. Get someone who's going to help you do a modification, see if that works out for you. If you can save your house, do that. That's, from a lawyer who's been doing this for a very long time, you do not want to be in harm's way unless you have to be. That is just, the lesson I've learned from all this is, you're fighting against the most powerful, wealthy banks in the world in a lot of these cases, and the law is favoring them. You didn't pay your mortgage is a good defense to a lot of the defenses that we raise. And I have always stood in the trenches and used every procedural rule and strategy that I've been able to develop over years to give my people the chance to stay and to put pressure. And I firmly believe that there's another there's a path of less resistance, that if you go in and you fill out the paperwork correctly and you have a good lawyer helping you, you should be able to get whatever they're going to give you without getting into a whole big fight. But sometimes whatever they're going to give you doesn't answer your questions, doesn't solve your problems. And that's when you need to get ready to litigate. And I'll just say this, you get a lawsuit served on you, you have 20 days to respond. You have to have either a lawyer respond, or you can file something in the courthouse. But if 20 days go by and the bank files what's called a motion for clerk's default, the clerk's going to open your file, looking to see if there's any response. And if there's no response, they're going to enter a clerk's default, which means you just waived all your defenses. And even if you have defenses, you're going to have to explain why you didn't respond within the 20 days. And if you don't have a good excuse for that, your defenses are waived. So getting involved, I used to recommend to clients, send a letter to the clerk that says, with the case number on it and your information, I need more time to find a lawyer, period. Don't tell them I'm trying to do a loan mod. Don't tell them your life story. Don't tell them about all the trouble you're going through, why you can't pay. Like, just, I need time to file a lawyer, and that will give you more time before they can actually, they'll have to go to the judge and get the judge to get a default, which means they have to set a motion. They have to, get it set on calendar. They have to, have a hearing. And, as long as you get there, you can, as long as someone gets in before that, you're going to be fine. I've had cases that have gone on for years where there's been no answer, but they never got a default. And and then when they go in to get the default, I file an answer right before, and now they can't get a default because that's, once there's an answer, there's no more defaults. So that's a little bit about when you get served. If you're getting letters in the mail that say you've been filed on, that's when you need to start looking and figuring out who's going to work with you. And my recommendation is look for people who've been in the battle. Don't take anyone who's, who just has some fancy marketing, because those guys, a lot of guys have a lot of money and not a lot of, desire to fight these kinds of cases. Now, it's already after 8, and we're going to leave some time for questions. But one of the things that I want to talk about before we leave foreclosures and get into bankruptcy is, so what does the landscape look like today for foreclosures that's different than it was a decade ago? And once the case is filed and once you have a lawyer appear in your case, things are different now than they were back in the day. Like, the Supreme Court has already created these new case management orders that happen in every case, and they're going to set deadlines, and those deadlines are for like everyone to do everything that needs to be done in litigation. And a lot of times those, I feel like it's almost unfair because you can't prepare 50 cases for trial at the same time because it's too much work. And a lot of the big law firms have all the resources they need, but the people who are going to do this work are going to go into court, and a lot of these orders are going to basically shorten your timeline to do the fight. And then they come in with a summary judgment motion, and the standard is, do you have anything that you could show that creates an issue of fact that you didn't pay your mortgage and that they're the people who have the right to foreclose? Now, I think there's tons of issues about all of that, and that's why I do the work that I do. And there are some judges who agree with me and some judges who don't. And I don't know which judge is going to be on your case and what their positions are. Some judges are very much more in line with you should pay your mortgage, and other judges are very much more in line with this just litigation and everyone follows the rules. But these new rules of case management and summary judgment are by design going to shorten the timeline for these foreclosures, and make you present your defenses and fight with an urgency. So I think that it's important to recognize, when you start off in this process, ask for your loan mod, do what they ask you to do. If they give you one, take it, unless you can't. And then if you can't, be ready for this litigation. Now, Jackie had mentioned before that there's this other thing that I want to kind of end our talk about, which is bankruptcy. And I'll tell you, I used to be in a group called BNI. It's a networking group, and it's like there was like 100 of us, from every different profession, lawyers and plumbers and AC guys and architects, whatever it was. We all share business with each other. And I remember there was a bankruptcy lawyer that was next, that was part of the group, and I was the foreclosure defense guy. And we used to have these like commercials we would do. And my commercial was always like, don't declare bankruptcy, declare war. Let's go have a big fight. That was my pitch, right? And my buddy, the bankruptcy lawyer, would go, don't declare war, declare bankruptcy. And there's a truth to both of our positions, and I think that, there are some people who are best served by a bankruptcy, that could get all your debts harnessed together and you can resolve them all. And maybe you save your house, maybe you don't, but you get out of this, you move on with your life, and get yourself back on track. And, then there's other people, like I had a client who's been in our house for years. We've been fighting it and we were going to go to trial. And she knew that she didn't want to go to trial because she didn't necessarily think that, she had the best chance of winning. So she filed a bankruptcy. And, and one of the good things about bankruptcy is there's something called the automatic stay. You file a bankruptcy and automatically litigation stops. Everything, if a debt collector comes after you file a bankruptcy and they're on notice that you're in bankruptcy, they get themselves in a lot of trouble with the court because you're not allowed to do that stuff. But, bankruptcy, in my opinion, has always been the nuclear option. But there are people who do bankruptcy who would certainly say that you could use it earlier on to help you in a lot of different ways. So if you are considering bankruptcy, it's usually because you have a lot of debt. I wouldn't do it necessarily just for the house. I'd go through foreclosure first to see if you really need to get there. But, Jackie is kind of our resident expert with the bankruptcy stuff. And I just would really like to hear, Jackie, how do you see bankruptcy fitting into, this, arsenal of weapons that we have to help people who, are in danger of losing their home?
I love bankruptcy to help homeowners stay in their homes. It is, I think, a tool of last resort, because if you can get a modification, that's going to be cheaper for you in the long run, and potentially not a faster workout. But if all else fails, if you've defended, you've tried the loan mod, and bankruptcy is your last option, I love it. Having represented borrowers for such a long time in the foreclosure court system, the judges are inundated with literally thousands of foreclosure cases. And the objective is get it off your docket, move it along, try the case if necessary, probably resolve it at summary judgment. But it's a very quick process. And it's not the law, the foreclosure law, it does not favor the homeowner in any way, shape, or form. Bankruptcy court is essentially the opposite of that. The bankruptcy code is designed to help homeowners stay, not homeowners stay in their home. The bankruptcy code is designed to help debtors get the relief that they need, to allow them an opportunity to get a fresh start. I mean, that's the definition of what a bankruptcy is for. And for those who are eligible to pay their mortgage, but perhaps they got behind, there's different strategies you can take in a bankruptcy case to get back on track. And the court is there to really work with debtors to get them the relief that they're seeking. So that's, I think, in terms of a forum for borrowers to deal with mortgage foreclosures, I think it's an excellent forum. I love being in bankruptcy court for that purpose. I also think that depending on your circumstances, there's a lot of power that a debtor has in bankruptcy. There's a mortgage modification mediation program. Again, like if you can do the loan modification outside of bankruptcy, that's going to be certainly cheaper for you. But if you're at a point where you've got a foreclosure sale, you've exhausted your efforts in bankruptcy court, you've exhausted your efforts with the lender directly through a loan mod, then going ahead and applying for it through bankruptcy is an option. And it's nice because there's a system. Going back to one of the questions Bruce had before, what are one of the pitfalls that I saw? It was clients coming to me and saying, look, here's my stack, literally this thick. I submitted it to the mortgage lender and I've got nothing. I think what Robert was touching on is really diligence and organization. When you're applying for a loan modification, you can't do it haphazardly. You have to have a plan. And part of that is, just like he said, don't just pick up the phone and call. Have your piece of paper, be ready, and document it and keep track of everything that you've done. One of the biggest things I saw with my clients was documents going stale. And so my client says to me, well, I turned in the bank statements, I turned in this, I don't understand why they're asking me for it again. And it was a vicious cycle, which is by the time they get all the documents they need, because you're sending it piecemeal, you're sending your, bank statement here, you're sending a pay stub here, a tax return here, a form to get your tax return. But by the time it's all compiled together, and they won't look at it till it's all together, the document that you sent maybe 2 months ago is now outdated. So now it's stale. And so what I tell my clients when they're doing a loan mod is the organization that Robert suggested, I tell them, make it your job. Pick a day, Tuesdays and Fridays. I'm going to check in with the lender. What do you need? What can I send you? What are you missing? And then the fax is great because you get a fax confirmation that it went through. They're going to lose your documents. It's not going to get uploaded into the system. It's going to be extremely frustrating. You're not ever going to speak to the same person again. I mean, sometimes they have a dedicated loan rep, but it's rare. And so it requires a lot of diligence. The beauty of bankruptcy court, their program, it's an online portal. You submit it. There's no losing the documents. There's no anything. It's all tracked. It's all there. You have a mediator that's assigned, and you're able to work it out that way. And that's if you're applying for a loan modification in bankruptcy. Another option, and depends on the borrower's financial means, is a straight cure, which is if that's really good for borrowers who are only a couple months behind. If you're 2 to 3 months, 4 months behind, it's an ideal time if you've already applied for a mod to try to do a straight cure in bankruptcy, because you have the ability to force the lender to accept a payment plan. Again, one of the things I love about bankruptcy court is it gives my clients a great deal of power over the creditor, because the creditor in a foreclosure can say, well, you're 3-4 months behind, I'm foreclosing. In bankruptcy, if you have the ability and you can show you're a wage earner, you've got money that you can pay back, you can't pay the 3 to 4 months all in one day, but you have up to 5 years. So a couple $1,000s over the course of 5 years might be an extra $20, $30, $40 a month. I mean, that's all numbers in bankruptcy. And you force the creditor to accept that. So I love that aspect of it as well. But for somebody who's behind more than just a few months, it gets tougher. And if you are behind just a few months, first try the mod, but you do want to avoid foreclosure, because that's going to tack on a bunch of fees and costs that they can get under the mortgage, and it's going to make your payment higher. So it is something that you do want to do early on as best you can. But yeah, I know it's an avenue of last resort, but I love it because my clients are in a much better footing, I believe, in court to get the relief that they're seeking.
I think that
on that topic of the bankruptcies, the cure and maintain is a great option. And like Jackie said, the banks can't say no. And a lot of times when you ask for reinstatement figures, the banks tack on what they believe or what they want to charge for servicer fees, for their attorney's fees, and for a bunch of fees that you have no idea what they are. In the cure and maintain, you have the ability to challenge those amounts, and what you're paying in your payment plan, it's normally a 5-year or 3-year, and you divide whatever you're past due in those 60 or 36 months. So if it's, let's say the easy number is if you're behind 60 grand, it's your regular payments plus $1,000 a month plus some trustee fees. I think it's a tool that you can use within this whole process, and it is an option for people to be able to save their house and force the banks to accept that. And that DMM, the MMM program with the DM portal, the portal that they use, the banks can't play that game that Robert was talking about, and that everybody that's been involved with the loan modification knows the stale documents process. It's one of the most frustrating things that we all had to deal with. And explaining to the clients that, everything was submitted, you're showing the proof of all the documents, because we track all of those notes that were discussed by Robert with the modification, but that is a frustrating process. So bankruptcy is a tool that can be used. And as Bruce said, even if you have a sale date, you can file it right before the sale date to try to save your home and cure and maintain or do the MMM program. You shouldn't wait that long though.
And I think it's important to recognize, so there's a couple of, so there's chapter 7 and there's chapter 13. Chapter 7 is basically, here's all my debt, here's all my assets, take them. I'll take whatever I'm allowed to take out of that process, and I'm starting fresh. Good luck. Chapter 13 is, here's all my debts that I owe as of the date of my chapter 13, and I'm going to work out a payment plan, like Ricky was saying, 3 or 5 years. And that is, as long as you make your payments, you're safe. And one of the key things I want you guys I want to make sure people understand about bankruptcy and foreclosure is there is something called surrender. And this is something that has happened for a lot of people that you got to be careful about. If you go through the MMM program and you don't get a modification, they are usually, I believe it's like almost like automatic that you are deemed to have surrendered the property. And if you have an order in bankruptcy that you or finding in bankruptcy that you surrendered the property, that means in the foreclosure court, you have to surrender your defenses. You cannot go back into the foreclosure court and you can't say, hey, I got all my debts waived, I surrendered the property, but let me keep fighting you for the next few years with this foreclosure defense lawyer while I live in the house. And like the courts have put an end to that. And there's actually lawyers who've been disbarred for doing that strategy. There's people who've been sanctioned for doing that strategy. So just know when you go into bankruptcy, you don't tell the trustee about that Rolex watch that you get caught on Instagram posting about. They'll come arrest you and put you in jail because lying to a federal bankruptcy trustee is a crime. So just be mindful. If you're going to go into bankruptcy, make sure you have someone who's an experienced bankruptcy lawyer to help you, and make sure that you have an understanding of what strategy is going to serve you best to move forward in your life. So we have about 10 minutes left now, and I don't know how we can, if there's a way to open up the floor to questions from anyone. I see we still have about 30 people on on this live stream, and there'll be, we will be posting this to the website for the Miami-Dade bar. We're going to post it to the Floridians for honest lending. I'm sure we'll all have them on a link on our websites. But if you have questions, now is a good time to give them to us, because we're going to be, we only have a few minutes left in the program. So
Bruce, I'm seeing that there's a question, probably for Jackie. Is there a benefit to declare bankruptcy if you can't afford to keep your home and your only debt is your home? That's a good question.
Excellent question.
It depends on what you're able to negotiate outside of bankruptcy. So a lot of times lenders will be willing, if you've applied for mod, you can't get it, your defenses are exhausted in the foreclosure, and it's time to say, well, okay, I can't afford to keep this home. A lot of lenders will agree if you enter into a consent to judgment, which we've mentioned before. The bad part is you're saying, yes, I am consenting, I'm agreeing to you entering this judgment against me. The benefit is you can get an extended sale date often, sometimes 120 days to stay in your home for a few more months while they do the foreclosure process. Normally foreclosure auctions are scheduled 30 days out from the final judgment. So it'll give you a little bit more time. But you can also ask for a waiver of the deficiency. And so kind of like when your car is repossessed and people think, well, they took my car, I don't owe anything else. No, you still owe what's due under the contract. And so in a mortgage foreclosure, they can take your home, but they can still come after you for the difference in what it sold at the foreclosure auction and what was owed on the mortgage balance. And that's the deficiency. So if you're able to negotiate through, and usually this is where it helps to have a good attorney representing you, if you're able to negotiate a waiver of the deficiency, then there's no benefit to filing for bankruptcy if your only debt is your home. If you're not able to negotiate a waiver of that deficiency judgment, then bankruptcy is good for you in terms of wiping out your personal liability so that the lender cannot come after you after the foreclosure, garnish wages, bank accounts, etc. And I just want to answer real quick, because I also saw one of the questions was, and to elaborate a little bit on what Bruce said, the difference between a 7 and a 13, which are the main tools that I use anyways for foreclosure defense work. In a 7, you can apply for the mortgage mediation program, the mortgage modification mediation program, just like in the 13. But the cure and maintain that Ricky was talking about, where you force the lender to accept a payment plan because you're just hopefully not too far behind, but you're going to make an extra payment each month, that can only be done in a Chapter 13. So I generally try to file a 13 for my clients so that in the event the mod doesn't work out, we may have an option for a cure and maintain, and that way you're already in a 13. That's the big difference there.
So, yeah, go ahead, Rick.
What with the waiver offers that you get, one thing I can tell you is that if you, with the attorneys on this panel, the banks are normally more willing to give you a better offer. A lot of times when the banks are offering 120 days for a consent, we don't normally like to accept that because the risk reward for the borrower is not much. You're risking really a 30 to 45 day sale, giving up your rights to an appeal and to valid arguments that you would have basically for 90 days, for 3 months more. And you can always do the bankruptcy after, you know, if you qualify for the bankruptcy, to wipe off that deficiency if you have that. So I know when Bruce goes up, I don't know, I can't imagine what they're offering Bruce's clients, but it's certainly.
So I'll say this, you know, there are some of my clients that, you know, the offer is, you know, get out. And, you know, very rarely will I have a client that I'll go to trial. They know that. Like, I don't care. Like if you know, like I have my strategies. I know that I'm able to poke holes where I know that there are holes to poke. And a lot of times what we'll see is, you know, a deficiency waiver, a deletion of the trade line from the credit bureaus to make sure that it's off their credit. You know, I had one client they offered $25,000 to just last week. You know, I've had other clients get more money. I've had other clients get less money. You know, these are all possibilities, but that's because they know that there's going to be a fight. You know, most people, especially back in the day, their lawyers would show up for trial and say they're ready to take a consent judgment because they were never going to fight in the first place. So, you know, that's a strategy decision that you have to make, what kind of lawyer you want to go with. You know, but, you know, short sales, just I see a couple of questions before we wrap it up. You know, so the idea of the short sale in my mind is if you've got a deficiency waiver, if they're saying we're not going to come after you for the debt, and let me give you guys the big secret. In my 14 years of doing foreclosures, as many cases I have fought to the US Supreme Court and back, I have never had a single case where the client came to me after we lost the house, after we lost the appeal, after we lost the judgment, and within a year, the bank filed a deficiency judgment action. Never once happened in the hundreds and hundreds of cases I've dealt with. There was a time back in, they passed the statute, they changed the statute of limitations for deficiencies from 5 years to 1 year. And right before the 1 year expired, you saw a company called Dyke O'Neill that was basically filing a bunch of these deficiency judgment actions all over the country. And I had a bunch of clients come in and we basically just, you know, they didn't litigate them very hard. Very few of my clients ended up getting them, but there wasn't really anything to get from them at the time. But, you know, if there is a danger of deficiency or you want to button that up and you want to go for a short sale, make sure that your short sale includes a waiver of deficiency. You can ask for the trade line to be deleted. If you go through on a short sale that says I owe $500,000 and I'm selling the house for $400,000, I have seen people who've done that, and then the banks came back and sued them for the $100,000. Those weren't my clients because I never let that happen, but that has happened to people. You need to get, you know, realtors want to close your transaction and they do not necessarily care about your repercussions from a short sale. Lawyers generally do. And I work with realtors that I know are not going to try to slip that by my clients. But there's a lot of realtors I know back in the day, you know, their job is to sell your house and they get paid when the closing happens. And they're not about to say, you know, I'm going to delay this closing because I'm worried about your credit or I'm worried about your exposure to deficiency judgment. That just doesn't happen. So, you know, I think that, you know, we've kind of covered, this is exactly what I was hoping we could have gotten through. And I can't believe it's 8:29 and we're exactly here. I don't see any more questions that I don't think we've gotten to. There was one I saw asking about, is a short sale not going forward due to a bankruptcy? Most short sales don't go forward because there's equity in the property. I don't think the bankruptcy really factors into it, but you know, every lender has their own policies. But it's 8:30. It's been. I really want to thank the Miami-Dade Bar Association, Brett Berlin and Zanya. You guys have been phenomenal in helping us get this programming out. Floridians for Honest Lending. Thank you for all your support in helping us to promote this event, to get people to come in. Ricky and Jackie and Robert, you guys are salt of the earth, warriors and brothers in arms and all this. I really appreciate, that there are people out there who understand these issues and are willing to take their time on a Thursday night and share their knowledge for people. And I'll just say this, guys, we've witnessed the largest transfer of wealth from all of us to the 1%. So be careful who you vote for. Be careful how you go through life. It matters now. We do not want our children growing up homeless and penniless in the nation our fathers founded. And foreclosures is the way that they're going to get us, if they're going to get us at all with that. So thank you again to everybody. And, if you need any more information, please contact the Miami-Dade Bar Association, contact Floridians for Honest Lenders, contact any of our firms. We're happy to help you. Thank you so much.